All right, everybody, it is officially 10:01, so we're going to get started. As I have people coming into the waiting room, I'll just continue to admit them, but we are going to get started, so we're on time today. I'm going to tell you a couple of housekeeping things before we get started. My name is Emma Harbaugh. I'm the training manager for the Michigan Works Association. Thank you all so much for joining us today. We have two presenters and two presentations that I'm really looking forward to. As you saw, I did start a recording, so we'll be recording both H-2A this morning and H-2B training later on today, and those will be sent out as resources for you. For connection, for the best connection today, I would suggest keeping cameras off and muting yourself. That will help with, not losing anybody during the presentation. My job today, as we're going through these trainings, I'm going to be monitoring the chat. Please feel free to ask as many questions as you'd like. I'll make sure that those get answered, or raise your hand so you can unmute and ask the question yourself. But I do encourage, to utilize that chat, and I'll make sure to intervene when I need to get those questions answered for you. But I think that's all I have personally. I'm going to pass it over to our presenter, Ginger, this morning and let her and Ricardo introduce themselves. And if you have any questions or need help in the background, just let me know. Thanks.
Thank you, Emma, and thank you everyone for joining us today. My name is Ginger Vallejo. I am the manager for the Office of Foreign Labor Services with the state of Michigan. I'm grateful that Ricardo from DOL will be joining us, and I will let him introduce himself.
Hello, good morning, everyone. My name is Ricardo Caudillo. I am a wage hour investigator with the U.S. Department of Labor, Wage and Hour Division, and I'll be speaking at the second half of the H-2A portion. And I'll also note that we have Christopher Downing from Wage Hour Division. Chris, would you like to say something?
Thanks, Ricardo. Just to say good morning to everyone. Thank you all for allowing me to participate in this morning and this afternoon.
And Chris is an assistant district director at the Detroit district office.
Yes, thank you.
Thank you, Ricardo. Joining with me today is also our Foreign Labor Services team. If Esmeralda and Mercedes can just turn on their camera. We do a lot of interactions with individuals, so sometimes it's nice to see faces. They might populate, they might not, because there's so many individuals in the meeting. But I want to, again, thank you all for taking the time to join us today. I will be turning off my camera just to help with technology, making sure that I don't lose connection. So give me 1 second. So I do want to start off the meeting by saying this presentation is intended for training use only and does not enter any legal opinion. I'm presenting. Sorry, somebody just came in the office. So for today's objectives, we are going to be talking a little bit about the foreign labor program for the state of Michigan, provide an overview, and also provide recommendations to ensure prompt processing of your H-2A temporary foreign labor application. With us today also is our partner border state team from Indiana. So I wanted to just give them a hello and welcome them as well to the presentation. Please, if you have any questions, please feel free to put them in the chat or let Emma know, because I'll be more than happy to answer questions that I can during the presentation. So I will start with the basics, who we are and what we do. This is an overview of services provided by the foreign labor team. The central requirement of the program is to determine whether there are sufficient able and willing qualified U.S. workers available to perform the temporary and seasonal employment for which an employer desires to import non-immigrant foreign workers. Other functions include, we review the H-2A applications for compliance with relevant federal, state, and local regulations, collaborate with the Michigan Department of Agriculture for housing inspections. We post jobs on Pure Michigan Talent Connect. We train Michigan Works and State of Michigan staff about the role with H-2A programs, conduct agriculture prevailing practice and prevailing wage and practice surveys throughout Michigan to determine common employment practices and average wages. We also recruit and refer migrant and seasonal farm workers or any job seeker available to available jobs, and complete field checks when U.S. workers have been referred to H-2A connected jobs. Over the last 5 years, Michigan has seen a dramatic increase in the total number of employers applying for certification under the H-2A temporary foreign labor program. This is also reflected in the total number of agriculture clearance orders processed by the Michigan Office of Foreign Labor Services. So this is why we're having this webinar today, to kind of go over some of provide a process to employers so they can understand like where it starts and how it ends, and everything in between, so that we can work together to ensure that the applications are processed timely. For the use of foreign labor programs, Michigan has been in the top 10 states and has held steady at number 7 for the 3 of the last 4 years. So in the screen right here is what we get from the Office of Foreign Labor Certification. And for program 2022, or fiscal year 2022, Michigan was number 6 for the use of H-2A programs. And some of the employers that are the top 10 employers also conduct services in the state of Michigan. In PY 2023, the increase in foreign worker applications, along with changes in regulation and flag, has changed some of the review process, and we have worked to continue providing timely processing of job orders. In 2023, this is the second quarter for 2023, we are at number 8, and these are the numbers for the second quarter, for 2023. And as you can see, we're still within the top 10, but the program has grown tremendously that other states are coming in and utilizing to fill their labor needs. So I want to introduce you to our sister department, which is the Agricultural Employment Liaison. They are the outreach workers for the state of Michigan. It consists of 6 teams that are tasked with providing employment services to agricultural employers and migrant and seasonal farm workers. This ensures workers have jobs and employers have the workers they need to plant, cultivate, and harvest crops throughout the state. Through this team, we have a network of contacts across the United States to help recruit workers. As you file your application for foreign workers, please be aware that in ETA 798, Additional Assurances Letter F states, employers assures outreach workers will have reasonable access to the workers in the conduct of outreach activity. So I wanted to just point that out because we do sometimes get some feedback from the outreach team about employers giving them a little bit of a hard time getting in to meet with the workers. You should provide reasonable access, and reasonable access just means at the times that the workers are available. We are not, or they are not allowed to go onto work sites or come on site without asking or informing you of a proposed visit. So I just wanted to throw that in there. So if you see an outreach worker from the state of Michigan, this is where you signed on the ETA 790 to provide them that opportunity to meet with the workers. So here's where the process starts. For us in Office of Foreign Labor Services, we get notification via flag that a new application has been submitted. We download all the documents, the addendums, agent emails, and case attachments. So your employer file has all that, all those documents together. When we do that, we review the ETA 790 addendums and we work with MDAR to request your housing inspections. If we identify any deficiencies, a notice is sent within 7 to 10 days, 7 days, I'm sorry. And the employer agent has 5 days to respond, and we take about 3 days to update the job order and flag decision. If your application meets requirements, we'll just talk about that in slide 15. So as we were mentioning earlier, what are some of the things that we look for in the ETA 790? Well, we look for employer contact information, the dates of needs, number of workers, type of work, crop, housing, and transportation and meals. Again, I bring up the additional insurances that are in the last 3 pages of the ETA 790 because that's where you are signing to agree to those. And I just put an overview of them in the screen, but I just, again, wanted to just bring them to your attention because sometimes, they're missed because of the lettering. Do I have any questions yet or any on the chat?
No questions so far.
Okay, perfect. All right, so I will go to the next one. So reviewing the ETA 790A. So when we are reviewing the ETA 790A, we are looking to ensure that it meets the qualifications. I want to just emphasize that these regulations are not SWA regulations. We are provided guidance by the Office of Foreign Labor Certification. So when we're looking for the contract or the application of ETA 790, it is to ensure that it meets the qualifications. So we have some leadway in how we want to handle deficiencies. So if they're minor, like in the inability to view a full content of the ETA, in the ETA or the addendums, the use of GPS coordinates, incomplete, incorrect housing, those we can typically send an email and state, hey, this is not matching, this is not, or it doesn't meet the regulation, and we always will send a modification required. If it's major, which is some of the ones that we've been receiving here lately, include job orders with multiple or incorrect SOC codes, position descriptions, and pay week inbound, outbound transportation is not clearly explained. And one of the other things is in section D of your ETA 790, one of the most common ones missed is number 9, which is you're identifying which is the entity that's in charge of inspecting housing. It is important that you check off at least the SWA or the other state authority boxes. Okay, so this is an example of a deficiency. And I know that these changes are new and there are, all of us are learning as the changes are coming. But here's an example of the verbiage that may constitute the assignment of multiple codes. So in here, they are requesting an ag equipment operator, yet it also inserts tasks that are involved with the operation of a semi and that require the license for a CDL driver. In this case, instead of having the ag equipment AWARL of 1734, we will then send a deficiency notice with a couple of options and inform of the wage of $25.09 for drivers. So some of the suggestions that would be for that would be on the modification would be to remove the language and keep the 2091 code, or remove the language and create an additional ETA for the 3032 code, which is the CDL, or keep the language and update the wages. So you would be able to have a worker that is working in as a agriculture equipment operator and a truck driver, but you would have to be paying the highest AWAR, which is 2509 or 09. So just so that you know, those are some of the more common deficiencies that we receive. And all of these changes will affect all the workers in that one particular contract. And here's another example of verbiage that may constitute an assignment of multiple SUC codes. Oh, this is the previous one. Another one is the H-2A adverse effect wage rate. And no, again, these are new changes for all of us. So as we're working through the changes, you know, we try and work our best. We pick up the phone, talk to individuals, let them know of these items that might be happening. If we see it happen more than once, especially if we're dealing with and representing agent, we'll reach out to them and say, hey, you know, the last 3 applications had this verbiage. Can we move? Can we ensure that the next ones that are, if you're going to have next ones, have this so that it can eliminate us having to, you know, file a deficiency, create the letter, and it delays the process. And up to this point, with the communication with the agents and employers, we're pretty grateful that, you know, we have been able to establish those working relationships so that we can move the process along. But I'm going to show you in the next slide some of the job occupation codes that still fall under the 1734 per hour. And then I'm also going to talk a little bit about some of the job tasks that are sometimes added, especially under the 45-2092 farm workers and laborers, crop, nursery, and greenhouse. Sometimes we get language that includes transporting workers in a bus. So that would constitute us filing a deficiency and informing the employer or the agent of the code, the additional code, and the additional pay. One of the ones that we had not seen in our office, but we got a deficiency from Office of Foreign Labor Certification, I'm sorry, was a fence erector. The fence erector gets paid more than a farm worker laborer SOC code. So all those things, as we see them, if you're maintaining fence, that is perfectly fine. But if you're building from the ground up, that is when the Office of Foreign Labor Certification has provided guidance to include the fence erector SOC code. And this one here is one of the probably most common out of all the 3. We have been struggling a little bit because when we are reviewing the ETA 790, what the ETA 790 provides and what we see on flag must match what we receive when we ask for an inspection report. So some of the things that we are noticing is that some of the addresses, you know, might miss the street, avenue, north, south, or they're in the correct county. We have been working very diligently with MDARD employers and agents, and we appreciate everybody for their patience as we have been working to correct, remedy those deficiencies. Another one is the time frame of licenses does not fall within the contract period. The state of Michigan, the licenses are only provided for a year, which is January through December. Some of the applications come in with work that flows into 2024. So those are some of the items that we've been working with MDARD to try and establish a system of how do we ensure that come January 1st, the housing is still compliant. And it is something that is employers should be thinking about as they're submitting these applications. So one of the things that we have been working with MDARD is in October 1st, we are going to submit a list of the ETAs that flowed into 2024, so we can try and reach out to the employers to update their license before the year ends. So please be aware that if you do receive something like that from MDART and it's in October and you're thinking, why, if it's 2024, it is something that's coming from our office so that we can ensure that the housing is still compliant going into 2024. Any questions from anyone, Emma?
No questions so far. I did have someone ask if presentation slides will be made available, which they will, but no other questions other than that.
All right, thank you. So another one is multiple employers using the same housing within the same period. That is something with the new flag system. It is, you know, it can happen sometimes, and it is something that the Office of Foreign Labor Certification has been informing us of when they come across that. So just be mindful if you are renting your housing or if you are renting housing from somebody, you want to ensure that nobody else has the same timeline as you, because this could delay your housing process, your application process. And the other one is when we receive the H-2A application and it indicates that there's going to be 60 workers. And when we get the housing back, the inspection report, it says it's only available for 55. Those are some of the things that we will identify as deficiencies, and we will work with you and MDART to try and find a solution. All right. The ETA 790 contents to the job order. Pretty much what happens when the deficiencies have been remedied and we're ready to approve the job for interstate clearance order. We work together with the Michigan Works agencies as well as the outreach team. We distribute that information. We identify what's called an order holding office, which that is where the closest Michigan Works to the area of intended employment. With the contents of the ETA 790, we will create a job order. And in the job order, it will describe everything that the employer pretty much identified as a task and a requirement. We also will create a referral log and send to those order holding offices. We then update the flag decision and provide notice. Well, that's provide notice to the Michigan Works office. The job order is now an interstate recruitment. And this portion here is very important because within the referral, I believe it's letter G of the referral on your ETA 790, you indicate, you know, the contact person for a referral, a phone number, and a time. And you must be available during that time if you get any potential referral or referrals from either the Michigan Works office or the outreach workers. An employer must not reject an applicant simply because they do not want to displace an H-2A worker. They must entertain all referrals of U.S. domestic workers through 50% of the employment period. That is identified on the referral log for the order holding office contacts. And that is also identified on flag when we update the 790 portion of it. Okay. So during this step, the next step is the Office of Foreign Labor Certification will review your ETA 790 plus any documentation you submitted, usually with your 9142. At this stage, you might get another NOD, depending on the review of the Office of Foreign Labor Certification. If you do not, and your case proceeds on to notice of acceptance, that notice will provide you specific instructions of how the employers to attempt recruitment of U.S. domestic workers for the H-2A job order. It also details the specific of submitting required forms and report detailing the attempts to recruit U.S. domestic workers. on our end, we also submit that, and we work very closely with Michigan Works and the outreach team to remind them of the importance of sending those referral logs, because those referral logs is what's used to identify if there has been any referrals within the state during this period. So once all required documentations and all processes have been completed, USDOL will issue a notice of certification. This is when the employer is authorized to recruit foreign workers, facilitate employment authorization, and worker. This is really important that I just mention it. I know that Ricardo is going to be talking a little bit about compliance, but I just wanted to just I wanted to repeat that workers authorized under that H-2A visa are only authorized to work with that specific employer recruiting them, unless a transfer is authorized by the U.S. Citizenship and Immigration Services, or unless the employer during that time period informs and gets approved to add additional work sites. But that is something that the Office of Foreign Labor Certification will get, that is not something that our office will handle. And once again, during this whole process, it is important that you entertain any referrals of U.S. domestic workers through the 50% of the employment period. So once your application has been approved by the SWA and the Office of Foreign Labor, well, by the SWA, we no longer have access to make changes to your job order. All requests need to be routed to the NPC. These are some of the contact emails and information for H-2A. The only thing that the Michigan SWA will handle after the case is approved or certified is any changes in housing. We have seen a couple come through where an employer and agent, for some reason or another, the housing is not meeting the need and they need to add additional housing. Typically what that is they'll send an email and they'll send an email to the Office of Foreign Labor Certification, and then they will CC the Michigan Office of Foreign Labor Services. And then we, on our end, will go ahead and submit a new inspection request to the Michigan Department of Agriculture to get a inspection report so that we can go ahead and let the certifying officer through FLAG know that the housing meets the criteria. And I just want to go over again just a couple of tips to ensure the seamless processing. We submit your housing inspection and license applications to MDART early. Ensure your housing is available for the duration of the contract. Make plans for dual year contacts. Make sure all housing contracts or leased housing is signed and executed prior to submitting. Double and triple check the ETA documents to ensure that all conditions of employment and assurances are clearly detailed in the content of the job order, and all information is correct prior to submitting your application. Make sure that the company contact information for the referral and hiring section is accurate. Failure to answer calls or emails from applicants can result in a negative action. If you are using an agent, make sure the power of attorney or agency representation documents are signed and executed. And all communication intended for the Office of Foreign Labor Certification should be emailed to leo-flcoffice@michigan.gov. And I think the last and most important one is let's be patient with each other and work together to ensure that foreign worker requests are processed timely. And this is our our foreign labor team. It consists of myself and 3 analysts. And just to kind of give you an overview of the workflow we have, together with H-2A and H-2B for FY23, we have reviewed and processed over 1,200 applications. So I am so very grateful to this team and the hard work that they put in. So I just wanted to throw that in there. And lastly, are there any other questions? I did want to just quickly end with saying that we do have a monthly newsletter where we put in announcements, information, everything that's happening within the Agriculture and Foreign Labor Services, which is both teams. You can register for the newsletter when our website is at www.michigan.gov/AFLS. And if I don't have any questions, I want to thank you for taking the time to join us today. I hope you find this information useful, and I look forward to working with you. And with this, I will go ahead and let Ricardo take over. Thank you so much for your time.
Was there a question or a comment?
Doesn't look like there were any questions. Someone did do a clapping hand emoji, so claps for Ginger.
Yes. Okay, well, good morning. I'll start by thanking the host for inviting us to talk about the H-2A program, and I will start my presentation.
Oh, cute.
Okay. Can we confirm that the presentation is up?
Looks good.
All right. Okay. So this PowerPoint presentation is available through the Wage and Hour Division website. My understanding is that a copy of the presentation will also be provided to attendees. I may not spend a lot of time on some slides, so feel free to ask questions if you would like some more information or to clarify a slide. The Immigration and Nationality Act authorizes the lawful admission of temporary non-immigrant workers, and the section of the INA that refers to agricultural labor or services of a temporary or seasonal nature is H-2A. There are a number of federal departments and agencies involved in the program. There is the U.S. Department of State, U.S. Citizenship and Immigration Services, or USIS, under the U.S. Department of Homeland Security, and Employment and Training Administration, or ETA, and Wage and Hour Division, or WHD, under the U.S. Department of Labor. My agency, the Wage and Hour Division, enforces the contractual obligations related to wages, transportation, meals, and housing. To participate in the H-2A program, employers agree or attest to comply with certain obligations. Employers agree to engage in good faith recruitment of U.S. workers, and this includes reaching out to workers who worked the season before and were laid off at the end of the season, and hiring new U.S. applicants if they are qualified and eligible to work. Lastly, under recruitment, employers must offer U.S. workers terms and conditions which are not less favorable than those offered to H-2A workers. Employers cannot lay off their U.S. workers and then hire H-2A workers. If an employer terminates a worker, or if a worker voluntarily abandons the position, employers are required to notify the Department of Labor. If a worker is an H-2A worker, then the employer must notify the Department of Homeland Security. Employers must pay the adverse effect wage rate, or AWER, if there was prevailing wage, collective bargaining rates, or federal or state statutory minimum wage that is higher than the AWER. Employers must comply with the highest rate. And here, employers run into trouble here where there are deductions from wages or hours worked, and these deductions bring the wages below the AWER. An example would be if an H-2A worker, had to pay rent each pay period, their wages minus the rent deduction divided by the total number of hours worked for the pay period would bring the H-2A workers' wages below the AWER. H-2A workers must receive a copy of the work contract or a copy of the job order that was submitted to the Department of Labor and approved by the Department of Labor. The work contract must include the beginning and ending dates of the contract period, as well as the location or locations where the work was done, any and all significant conditions of employment. It includes payment for the transportation expenses incurred, housing and meals to be provided. So it specifies the days workers are not required to work. It specifies any approved experience requirements or productivity standards. It includes the hours per day and the days per week each worker will be expected to work. It will include the crops that will be worked on and each job that will be performed, the applicable rates for each crop or job. This pertains to piece rates. Any tools, supplies, and equipment will be provided at no charge. The workers' compensation insurance will be provided at no charge. And it will disclose any deductions not otherwise required by law. All deductions must be reasonable, and any deduction that is not specified or disclosed is not permissible. Employers guarantee to offer H-2A workers employment for a total number of hours equal to at least 3/4 of the workdays in the contract period. Employers must provide housing at no cost to H-2A workers, and the housing has to meet the OSHA or ETA standards for labor camps. If an employer uses rental accommodations to house workers, the employer must pay all housing-related charges directly to the housing management. Employers must provide local transportation at no cost to the H-2A workers, and the transportation must meet all applicable safety standards. The vehicles must be properly insured, and they must be operated by licensed drivers. Employers must reimburse workers for their reasonable costs incurred for inbound transportation and subsistence costs. The inbound transportation costs begin at the place of recruitment, which means their homes if that is where they first received calls about the job. Employers must provide or pay for the outbound or return transportation and daily subsistence as well. Employers must keep an accurate record of the number of hours worked or number of hours offered each day and the hours actually worked each day by the workers. Employers must give each worker an earning statement, or commonly known as a check stub, and the check stubs must include the federal employer ID number. So the FEIN is a common omission that we find. Employers cannot keep or hold passports, government identification cards, or other immigration documents. Employers cannot seek or receive payments from H-2A workers for anything related to the H-2A labor certification. This includes attorney or agent fees, application or visa fees, or recruitment costs. Employers cannot discriminate or retaliate against anyone who filed a complaint, asked about their rights, or asserted their rights under the INA or H-2A regulations. And lastly, the public is welcome to call our office and ask questions or discuss concerns. You are welcome to contact the Detroit District Office. That phone number is area code 313-309-4500. And it may be a good idea for us to include that number in the chat.
We did
So,
have-
sure,
we did
go
have
ahead.
one question in the chat. Question is, can the driver's license be from their home country as long as it is not expired?
Yes, so I did research this on we encountered it before, and my understanding is that we are going by the applicable laws and safety standards. So my understanding is that the state of Michigan will allow a foreign driver's license if that driver's license has a English translation. And I believe if you go to the Secretary of State for for Michigan, there's a more comprehensive list of countries and where their driver's licenses are accepted with, again, an English translation.
Do we have any other questions from anyone? If you do, feel free to unmute or put them in the chat for us. Okay, hearing and seeing no questions at this point. If anyone here today does have any questions that they think of afterwards, feel free to shoot me an email and I can get those over to our trainers. I'm sure they'd be more than happy to assist. Thank you, Ricardo and Ginger, for your time this morning. A quick announcement before we are finished up with H-2A. If you are attending H-2B later this afternoon as well, this will be the same link that you'll use for the training. I am going to stay essentially on this link so you can get back in when you need to. We'll start again promptly at 1 p.m. Thanks again, everybody, for joining us, and to our trainers. If you have anything else, I will be sending out a follow-up email with the presentations that we went over today and with the recording. But thank you guys so much.
I'll point out in the chat that Esmeralda kind of clarified for us that the translated licenses or the English translation just need to be translated by someone who's bilingual. So thank you for that.
Awesome. Thanks, everybody. And we'll see you at 1 if you're coming on for H-2B. So we may have some friends that will stay on, muted and with their cameras off, that's totally fine. I'm gonna leave the Zoom. Actually, let me pause my recording first.